Right from the start, this isn't just an argument gone wrong. This is a strangulation allegation. And legally, that changes everything. In domestic violence cases, choking is often considered a major escalation because it shows control and can turn deadly in seconds. So as you watch this, ask yourself, is this a man owning his actions or slowly rewriting the story?
Put your hands around the throat of apparently your fiancée and choked her out. What kind of person does that?
Not a person in a good place and drinking like I was, Judge. I've had to live with every day that I put my hands on her and I lost my cool in a moment, and I just wanted her out in that time. I thought that was the right decision. And in that moment, that wasn't ever the right thing to do with drinking. And I just wasn't thinking either in that time. I wanted her out, Judge. We were arguing.
Okay. So why'd you punch Layla in the stomach?
That never happened, Your Honor.
It's in the report.
That's what they say it is, but that never happened. I grabbed her and I moved her directly from my living room 10 feet to the door and out the door. My daughter had hit me at the time and I knew she was there. I did not stop in any time. Motion never hit my child. I have 7 children that I'm involved with every single day and raise, and even my other 3 that I don't get to see, that I still see them every weekend. But again, I'm not a violent person towards my kids. I'm not.
So Layla lied to the police?
I believe it was a lie. She's had issues with that in the past. She's 9. Not with issues in this situation, but lying, and I think she was scared. I don't know, but I know that I never turned and I didn't put hands on my child.
The report says that she pushed you, trying to get you off of her mother, then you turned and punched her in the stomach, and she told the police that she had stomach pain after being punched by you.
I know that I did not turn and hit my child. I think that she was scared. I did not hit my child, Judge. I know that for a fact. She didn't push me. I was pulling her out the door. I had the door open, and she was hitting me in the side of my head and face, which I got that lip from it, but I did not ever stop at any point to hit my child. When I believe in the investigation as well, she admitted that she was lying through an investigator because she wanted me to be in trouble for her and her mother fighting. She felt that I needed to be in trouble for it.
So was Jessica lying when you said that you choked her out?
I don't think I choked her out, Judge. I did grab her, but I even told the officers as well. I did grab her by the neck and her coat that she had on and drug her out. I didn't choke her. Choking her, I don't know. But I did grab her by her neck and her jacket, the side of her arm, and yanked her and drug her out to the door.
The report says that you put 2 hands around her neck and choked her for about a minute.
Did you catch that shift? First, it's, I didn't choke her. Then it becomes, maybe I choked her while that was occurring. That's what courts call minimization. When a defendant admits just enough to soften the blow, but resists the full weight of the accusation. And in sentencing, credibility is everything. The judge isn't just listening to what he says, she's measuring what he avoids saying. If the story keeps changing, trust starts collapsing.
That to be true, Judge. I was drinking, like I said, but I just grabbed hold and pulled out, moved her out. I mean, I obviously maybe choked her while that was occurring, but I didn't choke her.
You dragged her out of her house like somebody would drag a dog out of the house. They need to go outside, right?
I think that sounds like a lovely way. Yes, sir. Just pulled her outside.
You dragged her out like a dog. No? Okay. All right. Ms. Robinson, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Your Honor, I'd like the court to consider that the 12-month cap was offered by our office. The recommendation from the agent was prison. People are sticking with that offer because of the statements we have had from the victim since. So I would ask the court to sentence pursuant to the offer that we made. However, I would ask the court to maximize the amount of time that he gets here so that when he's out, if he violates again, prison is all that is left. I think it is important to note that the minimization here leads me to believe that all of the work that is being done is simply for the purpose of looking good to the court and trying to avoid jail time. It doesn't actually seem to be anything genuine by the defendant. He just, every question, minimized what happened. You know, he said he just took her outside. Ms. Frost indicated to the officer that when he dragged her outside, he body slammed her so hard onto the porch that she urinated herself. The fact that his daughter, who he claims was punching him, but he put no hands on, felt the need to intervene as he was attacking her mother, I find that to be problematic. We have heard from the victim. She has indicated that she wants all of this dropped. She doesn't remember it and makes a point of telling our office that she can't afford to live without the defendant, that he pays the bills. I believe that this is a family that is in a situation where the fact that he is the provider is leaving them in a state of needing to be controlled, even in the last, 2 minutes where you questioned him. I know you heard this, but you asked him what kind of person chokes someone out. He said, oh, someone not in a good place who's drinking. And then later when you said you choked her, so that's what it said. He said, well, I don't really think that happened. So I would ask the court to sentence pursuant to the offer that was made. We will dismiss the new charges as we said we would, but I would ask the court to consider all of that when deciding how much of this time you should serve and before making any decisions about the no contact order. Thank you, Your Honor.
One question for your,
yes, Your Honor.
Both of you. The 2024 domestic and district court here on the PSI, it shows it was pending with a sentencing date of March. Did he end up pleading to that? Was he sentenced on the domestic district court?
I don't recall. Were you on probation? 6 months. Yeah, he thinks he may have been on probation on that one.
I did 6 months of probation in the district.
6 months of probation in the district.
And was the victim in that case Ms. Frost as well?
I believe she was. She's here today.
Your Honor,
Yes.
My notes indicate that there was a deferred sentence on the misdemeanor domestic violence in the district court here.
Okay. Did he successfully completed the deferral?
It appears so because he was discharged from probation successfully on September 26th of 2025, Your Honor.
All right, the PSI says he's got 90 days credit, rated 2 days on this file, originally 2 days, then sentenced to serve 87 days with 87 days credit, and he served 3 days before posting bond on this probation violation. Does that sound right, Mr. Watkins? You served 87 days in jail?
Yes, sir.
Judgment sentence says you served 45 days. You had 11 days credit, and you served 45 days. You ordered 45 days, 11 credit, you had 34 to serve.
Are you talking about the underlying charge, Judge?
Yeah.
Yeah, I think that, all right, so what had happened in that case, from what I recall, is that he bonded out, but probation thought he was still in jail while he bonded out, so that they had it 90 days
Okay.
of him
So
serving where
so
he,
you served 45.
I think that's the number, Judge.
Okay. That's what we had as a credit for 48. All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 11 months. The courts can exercise my discretion, sentence consistent with the advisory guidelines, consistent with the agreement in this case. It would be the sentence of the court that this defendant served 7 months in the Nuevo County Jail. I'll give him credit for the 48 days that he's served so far. Is going to be continued on probation with the same terms and conditions as was originally imposed. Mr. Watkins, the court probably would have given you the 11 months or a year, but you have been, say, I'll use the term generously, you've been working on some issues. I don't know if you've just been going through the motions or if you've been actually working on the issues, but at least you're trying. You got a long ways to go. You can tell from my court's questioning and dissatisfaction with your answers, you still haven't internalized what you did, I don't think. But you spent a fair amount of money, you're trying to do the right thing, so that's the only reason that you're getting.
7 months instead of a year. That's not mercy. That's conditional patience. The advisory guidelines allowed up to 11 months, and the prosecutor even pushed for maximum leverage. But here's the key. Judges look for accountability, not perfection. And when the court says you haven't internalized what you did, that's a warning shot. Because next time, there may not be another discount. So what do you think? Was this a fair sentence? Is progress enough when the harm was this serious? Let me know below.